Hi, in this lesson we're going to be talking about methods of ownership, or in other words, methods of taking title to property. And there are four different methods that we're going to speak about here. The first is severalty ownership, the second is joint tenants with the right of survivorship, the third one will be community property, and the fourth one will be tenancy in common. So let's first get into severalty. Severalty ownership, or tenancy in severalty as it's sometimes referred to, is simply ownership by one person, by one entity. And that could be a legal person such as a corporation or an LLC, or more commonly an individual. So severalty ownership is ownership by one person. So the question that arises with severalty is what happens to that person's property when they pass away? Well, the answer is it passes to their heirs at their death. In other words, it goes to probate. So as we talked about in a previous lesson, if they have a will, the will would be followed. If they do not have a will, then the courts would appoint an administrator to make sure the property went to their heirs by law. So again, ownership in severalty is ownership by one person, and at death that person's interest goes to probate, goes to their heirs. So that's severalty ownership. Now let's take a look at something more complicated, which is joint tenancy, also known as joint tenants with the right of survivorship. Now please make a note, joint tenancy is the same as joint tenancy with the right of survivorship. There is no such thing as joint tenants without the right of survivorship. So let's be clear on that. So I may say joint tenants or joint tenancy, or I might say joint tenants with the right of survivorship. Either way, it means the same thing. And joint tenancy, you see kind of a funny family group here, is typically done between family members. Why? Because joint tenancy has the right of survivorship. And most of you are familiar with the TV show Survivor, so let me use this as an example to demonstrate joint tenancy. So with the TV show Survivor here, and this is actually based on the very first episode, we have 16 participants. Well, let's say these are 16 family members, and by the way, they don't have to be related. Any two or more persons can hold title as joint tenants with the right of survivorship. So we have Gina and Hunter and John and a whole bunch of other folks here. And what happens is, with joint tenants, all 16 of them would own a 1/16 interest in the property. So each would own 1/16. And then as each one passed away, and let's say Hunter went first, then his interest would pass equally to the other 15 survivors. They are referred to as his surviving tenants. So, as each one of them passed away, or as each one of them got voted off the island, their interest would pass to the survivors, the surviving tenants. And of course, we would only eventually have one person left as each one of these got voted off the island. And who do you think it's going to be? We've got two left here. We've got Gina or Sarah. It's going to be Gina. Gina is the sole survivor of that 16 group joint tenancy, so Gina would then own the property in severalty, right? So let's talk about what's necessary for joint tenancy. In order to create a joint tenancy, we have to have what are called the four unities of joint tenancies. And you can remember them by the acronym TTIP, TTIP. Take a look at your course material. These four unities refer to time, to title, to interest, and possession. So the unity of time, all of the joint tenants must acquire their interest at the same time. And the unity of title, they have to acquire it through the same document, through the same deed. So actually, in a deed whereby the grantees are acquiring as joint tenants with the right of survivorship, all of them have to be named in the document, and they all acquire their interest at the same time. Now, the unity of interest means that all of the joint tenants must have equal interest, and all of these interests are undivided. What do I mean by undivided? Well, by undivided, I mean that you can't say, well, that's my half and that's your half if there's only two of you. You own half of the property, but your half is undivided. So, for example, you own half of every brick and every board and every electrical wire that's in the property. You own half of every atom that's in every brick and every board. So your interest is undivided. You can't say, if you and your spouse, for example, have a fight, you can't say, well, you take your half of the house, the kitchen and the family room, and you take the other half, the bedrooms and the bathroom. All right? All your interests are equal and undivided. And the last unity is the unity of possession. Now, the unity of possession means that, and it arises from the fact that your interests are undivided, that you all have equal rights of possession throughout the property. So remember the four unities of joint tenancy. If you don't have unities of time, title, interest, and possession, you don't have a joint tenancy. Now, let's take a look at some of the other criteria. First of all, joint tenants or joint tenants with the right of survivorship has the right of survivorship. Very significant, because what this means is, let's say that I have a will, and my will says that all my property goes to my daughter. Yet my wife and I acquire a property as joint tenants with the right of survivorship. By acquiring that property as joint tenants with the right of survivorship, what I've done is I've taken that property and I've selected it out of my will. So if I were to pass away, whatever property that I owned that was not as joint tenants would pass to my daughter through my will, through probate. But the property or properties held as joint tenants with the right of survivorship would go to, in that example, my wife. She would be referred to there as my surviving tenant. All right? She wouldn't acquire it because she's my wife. She's acquiring it because of the fact we named each other as joint tenants with the right of survivorship when we acquired the property. So joint tenancy has this right of survivorship. Secondly, it can be created between two or more persons. In the example that I just mentioned, it was me and my wife. In the first example I used, we had 16 unrelated people there in that game of survivorship. So two or more persons, they don't have to be related, but they have to be natural persons. What do I mean by that? I mean they have to be living, breathing human beings. I asked that question one time in class, what do I mean by a natural person? And a lady in the class said, no makeup? I thought it was a cute answer. All right, but by natural persons, we mean living people, as opposed to corporations or LLCs or other entities. Why? Because living people die, but corporations and entities like LLCs do not. So it must be two or more natural persons. And the other thing you have to realize is that when people hold title in joint tenancy, the individuals can transfer their undivided interest to third persons, and they can do so without permission of the other joint tenants. So, for example, let's say my wife and I held title to a property as joint tenants, and I decided I wanted to transfer my half interest to my brother. Could I do that? The answer is absolutely yes. I could simply, without my wife's permission, execute a deed for my 50% undivided interest in the property to my brother. And that, of course, would terminate the joint tenancy between my wife and myself, but it does not create a joint tenancy between my wife and my brother. Why? Well, think about the unities of joint tenancy. My brother acquired his interest at a different time through a different document, through a different deed, so he can't be a joint tenant with my wife. At that point, he would be what we'll see in a few minutes, a tenant in common. My wife and my brother would be tenants in common on that property. So that's our discussion on joint tenancy. The next method of ownership we want to talk about is community property. And community property, if you take a look at your notes, is property acquired by spouses during marriage. And there are some exceptions to community property. Property received by gift, devise, or descent are considered to be separate property. In other words, let's say that your parents gave you a piece of real property. Let's presume you're married and your parents gave a piece of real estate just to you, not to you and your spouse. That would be considered to be your separate property. Also, devise or descent, in other words, through inheritance. So let's say your grandmother passed away and in her will, she named you as the heir to a piece of real estate that she owned, and she didn't name you and your spouse. In that circumstance, that property would be your separate property. Also, property that's acquired while married, but where you use separate funds, would be still separate property. So for example, let's say prior to marriage, or let's say during marriage, you had some money that you inherited from your grandmother. That money, just you, that money is your separate money. And then you went out with that money and purchased a piece of real estate. That piece of real estate would be considered to be separate property, not community property. In addition, any property that you owned before marriage would not become community property after marriage unless you commingled it. Now, this is always a potential issue with separate property when you're married because it's very easy to commingle this property. For example, let's say that before you were married you owned a piece of property and after marriage you did not give your spouse any interest. However, you started to make, you and your spouse out of a joint account, made mortgage payments on the property. And over the years, your spouse also contributed maintenance and upkeep to the property. And eventually you got divorced. In that circumstance, it's possible your spouse could claim a community interest. So we're looking at the textbook definitions here of community property. So back to your notes again. Community property is property acquired by spouses during marriage, but property received by gift or inheritance, purchased with separate funds, or acquired prior to marriage remains separate property. So let's talk about Arizona law because Arizona is one of the 8 community property states. If you visualize a map of the United States, starting with Louisiana, go west to Texas, New Mexico, Arizona, California, skip Oregon, go to Washington, Idaho, and Nevada. Those are the 8 community property states. So community property is a minority of the ownership types around the United States. So when a married couple purchases property here in Arizona, it's presumed to be community property unless otherwise specified. In other words, my wife and I could acquire a property and without saying anything, the presumption would be under the law that it's community property. However, if we selected to acquire that property as joint tenants with the right of survivorship, joint tenancy and the rules relating to that would govern that property as opposed to community property law. So we can select it out of community property. Now with community property, the community is looked at as holding the property, but in reality each spouse has a half interest in the property. However, neither spouse can convey their half interest to third parties without the other spouse's permission. In other words, with real property, both spouses have to sign in order to convey any ownership interest in community property. So take a look at your notes here. Under C, both spouses must sign to convey real property. However, either spouse may sign to convey or transfer personal property. So make the distinction between real and personal property. For example, in a household, either spouse can go out and buy refrigerators and washers and dryers and contract with various companies to do and provide various services for them. That's personal property. But with real property, to sell or transfer any interest in real property that's community property, both spouses must sign. Now, the question becomes, what happens when either spouse passes away? Well, if it's held as community property, then when one spouse passes away, that property goes to probate and then obviously to their heirs. So for example, let's say that my wife and I hold property as community property. And my will says that all my property goes to my daughter. Well, any property that's held as community property at my death through probate will pass to my daughter, not necessarily my wife, because with community property, the deceased spouse's will is followed. There is no right of survivorship with what I'll call plain vanilla community property, as opposed to a right of survivorship in joint tenancy, or as we'll see in a minute, the right of survivorship with community property with rights of survivorship. Now, I'm a little bit cart before the horse here, but in just a minute we're going to be talking about community property with rights of survivorship, another form of community property. So let's recap. Community property owned by husband and wife, and it's the law of the land in Arizona unless they select some other method. Both spouses have to sign in order to sell that real estate, and at death, the deceased spouse's interest goes to probate, goes to their heirs. Now, let's talk about community property with rights of survivorship. Now, this is something that didn't exist in Arizona until the 1990s. All right, so in 1994, the Arizona legislature acted to create community property with rights of survivorship. One of the main reasons was that so many spouses liked this right of survivorship, liked avoiding probate. And the only way that they could do that was through joint tenancy with rights of survivorship, not community property, that plain vanilla community property we just talked about. So in 1994, the legislature enacted community property with rights of survivorship, giving spouses choices. They could still hold it as community property, where neither spouse could convey their partial interest to third parties without the other spouse's permission, but it did create the right of survivorship in community property. So it did away with probate. So if you and your spouse own property as community property with rights of survivorship, that even though your will might say, or my will might say, that all my property goes to my daughter, the property held as community property with rights of survivorship would pass to my spouse. The next method of ownership we want to talk about is tenancy in common. And tenancy in common is the method of ownership reserved for two or more persons. And that could be legal persons or natural persons. So you and a friend could buy a property, and since you probably would not want it as community property, well, it couldn't be community property because you're not married, and you probably would not want joint tenancy with the right of survivorship because you would want to be able to will your interest to your relatives, then the way you would take title would be as tenants in common. It could also be you and a corporation, or you and a corporation and a third party and a fourth party who's an LLC. So it's two or more persons, legal persons or natural persons, and it does not have the right of survivorship. So what happens here, if it's you and your friend who own the property, then at your death, your property would pass through probate. Assuming you had a will, it would go to your heirs named in the will. Similarly, if your friend passed away, you would not acquire any interest. It would pass to your friend's relatives or heirs through probate. So that's just a little on tenancy in common. Please realize that tenants in common have what are referred to as separate and distinct but still undivided interests. And let's take an example here. Let's role play a little bit here relative to tenancy in common. So let's say we're going to have three different entities acquire ownership in one property. So let's say a young lady who's a single woman decides to buy 20% of the property that we're going to invest in as a group, and she's going to buy her interest in severalty. And let's say we have a husband and wife, and let's say that's my wife and I, and we decide to put up 50% of the money, and we decide that we want to acquire our interest as community property. Plain vanilla community property, not community property with rights of survivorship. And let's say we have a father and a son who also want to put up 30% of the money, so they buy 30% of this property that we're investing in, but they want their 30% interest to be held between them as joint tenants with the right of survivorship. So individually, we have three separate and distinct interests, and these interests are undivided. The woman can't say, well, there's my 20% and there's the rest of yours. They're undivided interests. Collectively, what we have, since it's two or more separate and distinct entities, what we have is we have a tenancy in common. So let's see what happens when someone passes away. Let's say that the young woman passed away. Since she owns her interest in severalty, it would pass to her heirs. Go through probate, pass to her heirs. If she had a will, the will is followed. If she has no will, then the law sets out the order of descent. Let's say that I passed away. In that circumstance, since it's held as plain vanilla community property, it would not go to my wife, but it would go to my heirs. Now, if I named my wife in my will, then it would pass to her. But let's say again that I named my daughter, then my half interest in that property would pass to my daughter as opposed to my wife. What happens if dad passes away when he and the son own property as joint tenants with the right of survivorship? Well, his half interest of that 30%, his 15% interest in the property, would pass to his son because his son was his joint tenant and he was the survivor. So again, please realize a tenancy in common does not exist by itself. We have to have two or more separate and distinct entities, but they own the property in an undivided fashion. One last point. Let's say the woman on the left there owning 20% actually was a corporation or a limited liability company. Same thing would be true. That corporation or limited liability company, of course, does not pass away, but they could own a separate and distinct interest in the property with these other individuals. Now, in your course material, you have a little chart listing some of the differences between severalty, joint tenancy, etc. You might want to take a look at that, and that might help you decipher some of these particular issues. By the way, one last thing on tenancy in common. Tenancy in common. All right, the only unity that is necessary, you can see that on the far right there of that chart under tenancy in common. The only unity of title that's necessary is the unity of possession. So going back to joint tenancy, we have four unities: time, title, interest, and possession. In joint tenancy, they all must acquire at the same time through the same document. Their interests have to be equal, and they have unity of possession. Well, with tenants in common, the only unity that's necessary is possession. They do not have to acquire at the same time. For example, I could own 100% interest in a property and then convey 30% to you at a later date. We would be tenants in common. So we don't have to acquire at the same time, nor do we acquire the same title, nor do we have to have equal interests if we are tenants in common. The only unity necessary for tenancy in common is the unity of possession. Now, these methods of ownership can be rather confusing, and here in this course we only talk about the basics. And one of the things that can happen is sometimes you will wind up being with a purchaser, and the purchaser asks, which is better, community property or joint tenancy or community property with rights of survivorship? You've got to be very careful about this. If you're ever confronted with the possibility of, or a question about, well, which is better, your answer should be, well, there are differences, and this is really an estate planning issue and possibly a tax issue. So you need to speak with your professionals, with your estate planning attorneys and so on. You as a real estate agent never want to give advice relative to how to take title. Sometimes the best laid plans go awry. And sometimes when partners buy a property, let's say that you and I bought a property together and we hold title as tenants in common, or possibly as joint tenants, but let's presume it's tenants in common. Right? And down the road, we start seeing things a little bit differently. And I want to sell and you don't want to sell. And we can't come to any agreement. Well, in that circumstance, if we can't come to any mutual agreement between ourselves, how are we going to decide, or who's going to decide for us? Well, it may come to what is called a suit, a lawsuit for partition of the property. Now, if the property is partitionable, separatable, maybe it's acreage, and we could slice those acres into 2 equal parts or something like that, the court might do that. However, if the courts can't come to any decision, or if we can't come to any decision, and I might sue you to partition the property, typically what's going to happen is the courts will decide to sell the property, put the property up on the market, and then split or share the proceeds according to the percentage interest that we have in the property. So a suit for partition is a legal proceeding to partition the property in some way, shape, or form. So that's our discussion on methods of ownership, part 1. We'll get into some other aspects of ownership in another session.